Welcome back, everyone. We're going to resume our session now with a second panel dedicated to legal grounds in international climate litigation. Again, we will have a change in the order. So we are going to begin with Vladislava Stoyanova, hoping that she is online. Please. Yes. Hello, Vladislava. Thank you very much for being with us. Vladislava is an associate professor of public international law at the Faculty of Law at Lund University in Sweden. She's a Wallenberg Academy Fellowship. She's author of a very excellent book, so I would recommend it to everyone, of positive obligations under the European Convention on Human Rights within and beyond boundaries. It's an open access, published in this year very recently by the Oxford University Press. Okay, so for everyone, this panel will be a bit different. So we will have a first intervention, about 7 to 10 minutes each, and then I'll ask the speakers if they want to add things, if they want to comment on each other's presentations, as the goal of this panel, well, of the entire workshop, is to have a comparative perspective. So to have each other comment on the other legal system that they are not so familiar with, try to identify what is similar, what is different, and so on. So now I'll give the floor to Vladislava. Thank you very much again for being with us. I know that you will have to leave and then you will return. So please go ahead, up to 10 minutes maximum. Thank you.
Hey, thank you for having me. And I know you'll be very strict. So I have my PowerPoint. Shall I share it, or it's already shared? I see it on part of the screen. But I'll prefer to share it myself, since in this way it will be easier to manage it.
Okay, we are seeing your PowerPoint now.
Excellent. So what I have decided to do today, since my job, according to the instructions that I have received from the organizers, was to talk about the ECHR system. And the system was already partially presented in the first panel. And what I have decided to do is to focus on one specific question, on one specific substantive issues that I think is at the heart of these pending cases before the European Court of Human Rights. And that question, that specific issue that I have been trying to reflect upon, and this is work in progress that I'm currently sharing with you, relates to the principle of precaution. As I'm sure that we all know, the applicants, for example, in the pending case against Switzerland, the applicants invoke the principle of precaution. And what they argue is that precaution should inform positive obligations under the European Convention of Human Rights. Not only the applicants, but also the court, the European Court of Human Rights, when it formulated its arguments to the parties, it also, in the case against Switzerland, more specifically, it also invoked the principle of precaution. And here I will quote the question by the court: having regard to its margin of appreciation in the field of the environment, has the respondent states discharged its obligations under the convention redlined the provisions and relevant principles, such as the principle of precaution and intergenerational equity contained in international environmental law. So let's put now aside the principle of intergenerational equity and just focus on the principle of precaution, which, as the court said in its question, comes from international environmental law. And it seems that this principle of precaution is well established in international environmental law. On the one hand, it is claimed to be well established, although there seems to be a lot of uncertainty actually what it means. But the starting point is that it's a well established principle. And the question that I have been struggling to better understand is, if we take this principle and apply it in a human rights law context, what are the implications? So what I have been trying to understand, and again, this is work in progress that I'm presenting right now, is whether the European Court of Human Rights has actually developed positive obligations based on the idea of precaution. And a more general review of the case law prompts me to conclude that the answer to this question is not really. But then I also try to understand whether there have been any cases already, any judgments already delivered by the court where precaution has been involved in the reasoning, and I could identify such cases, and I'll come back to this. But more generally, it is the idea of prevention that has been guiding the development of positive obligations under the convention. And then the questions that I also try to understand better in light of these pending cases is whether in human rights law we have any reasons to exercise precaution against the principle of precaution. Basically, are there any reasons to be concerned of developing positive obligations in human rights law based on the idea of precaution? And I think we have such reasons. But at the same time, also a separate question that I've been trying to look at is whether in those pending cases, once the judgments are delivered in the beginning of next year, whether the court, very similarly to what the Dutch court did, might invoke precaution, but it might be the case that it limits the invocation of this principle and the development of positive obligations based on these principles to the environmental context, which is not that, which will not be that extraordinary because the court has done this in other contexts when it develops positive obligations. It develops certain standards by limiting them to a specific context. An example of such other contexts will be domestic violence or sexual exploitation, let's say, of children. So potentially this will be another development. But in any case, one of the novelties that emerges from this pending cases exactly relates to precaution. And now, if we go back to positive obligations as developed by the court, in very simple terms, these positive obligations will mean that the state has to take certain measures to prevent harm or the risk of harm. And the question here is what standards or what tests the court has developed to assess breach of these obligations. And the relevant standards and the relevant tests are knowledge, causation, and reasonableness. I don't have time to go into each one of them. What I want to do is to focus now on the question of knowledge. And because the court has consistently stated that for a positive obligation to be triggered in the first place, it needs to be established that the state knew or ought to have known about harm or the risk of harm. And now the court has also developed different positive obligations. And I'm going to focus on the positive obligation of adopting effective regulatory framework because this is the one that is relevant in the pending cases. So basically here on this slide, you can see how the court has formulated such a positive obligation. The positive obligation to take all appropriate steps to safeguard life for the purposes of Article 2 entails, above all, a primary duty on the state to put in place a legislative and administrative framework designed to provide effective deterrence against threats to the right to life. Something similar has been said in relationship to Article 8. What is very important here is that the court has said that when it reviews any deficiencies in the national regulatory framework that might be causative, that might contribute to harm, the court does not perform abstract review. So in contrast to certain national constitutional courts that do abstract review of national legislation, the European Court of Human Rights does not do abstract reviews, which means that it needs to be demonstrated how any deficiencies in the national regulatory framework have specifically affected the specific applicant. How all this relates to the question of knowledge. While the court does not perform abstract review, and while it still needs to be demonstrated that the specific applicant was concretely affected by any deficiencies in the regulatory framework, it is still enough that the state knew or ought to have known more generally about risk of harm. So in this sense, one can also say that the specific applicant simply happened to be a representative victim of some general failures, but it still needs to be, the court continues to insist on that idea of that standard of knowledge. And since the court has said that the assessment of breach of positive obligation is based on the standard of whether the state knew or ought to have known, this implies that actual knowledge needs to be demonstrated or a putative knowledge, and this is the ought to have known, standard. And here, this is the point where things become quite messy in the case law if one tries to understand how actually putative knowledge is applied by the court as a standard. So putative knowledge will mean that the state did not know, but it ought to have known, and this directly means that there's certain kind of normativity that plays in the background of the reasoning, and that it's not necessarily explicitly expressed in the actual wording of the judgment. Not only that, but again, if we have to be a little bit more specific, and here I have a quotation from the famous Grand Chamber judgment on Yildiz versus Turkey. And at some point, the court might say, well, it was not impossible for the administrative and municipal departments not to have known of the risk, which means that, well, they knew. But then if we continue to read the reasoning, then the court again says, well, they knew or they ought to have known. So at the end of the day, it's not clear in the reasoning of the court whether the court establishes actual knowledge or whether it establishes putative knowledge. So this putative knowledge, as I understand it, allows a lot of flexibility how to approach the question of knowledge. But more generally, the court continues to insist on that standard of actual and putative knowledge. And at this point, we should also more generally ask ourselves the question of why the court continues to insist on this. And I think that there are good reasons, because if the state were to be required to take protective actions as a matter of positive obligations in human rights law, so if the state were to take protective actions against any potential risk, regardless of knowledge about the risk, or even regardless of the immediacy of the risk, then we might be confronted with the problem of a too intrusive state. And this is a general tension that the court has to keep in mind when it develops positive obligations, because positive obligations are ultimately about more regulation by the state. And again, perhaps not in the environmental context, but more generally, we have reason to be cautious when we argue in favor of such a development of positive obligations based on the idea of precaution. Now, I already mentioned, and this is really my last slide, that one can identify certain cases where precaution has been mentioned. One of them is Tatar versus Romania. This is the standard reference given in the literature in environmental law when an argument is demonstrated that somehow precaution is also used in human rights law. But to me, this is incorrect, because in Tatar versus Romania, indeed, the court referred to precaution, but in fact, this was just one element in the overall reasoning in the judgment. The court also referred to many other deficiencies and failures by the Romanian authorities to find the breach of the positive obligation. So precaution was not really the basis for the establishment of state responsibility. In my research so far, I have found one single case where precaution was exclusively the basis for finding a breach of a positive obligation. In this case, is called Kotilainen and others versus Finland. Is a case that has nothing to do with protection of the environment or environmental damage. It has to do with a shooting at a school, where at certain point the authorities could have prevented, could have known that this shooting might happen, but they didn't take any measures. And the court assessed the responsibility of Finland based on the positive obligation of taking protective operational measures. It found no breach. It assessed the responsibility of Finland based on the positive obligation of adopting effective regulatory framework. It found no breach because of absence of causality, and then somehow introduces a totally new positive obligation that I couldn't find anywhere else in the case law. And this is the positive obligation as framed here. You see it on the slide, to take reasonable measure of precaution under the circumstances where doubt has arisen. And this standard has not, so far to my knowledge, been repeated in other cases. But again, this is ongoing research that I'm currently doing. So I might find something else in the process. Thank you very much for your attention.
Okay, thank you very much, Vladislava. I hope that you are able to join us later, but I know you have to leave soon. Okay, we'll now move on to Armando, once again, our hero. So thank you very much. No introduction needed by now, so please go ahead.
Although I took off my tie, I'm the same person, so no introduction needed.
Not sure, not sure.
So, in the previous panel, I mentioned you how daunting it is to bring a climate claim before international courts. However, these claims can actually be brought before the ICJ, before the ITLOS, based on the infringement of the Paris Agreement, general principles of law, and the law of the Sea Convention, plus, if you think about it, human rights law, investments, trade law, etc. In fact, I also mentioned before how unhelpful it is to use the Paris Agreement alone, but not to use it at all. It can be helpful to some extent. Well, to begin with, the wording of Article 4 of the Paris Agreement points to soft obligations established by states as duty holders, strangely enough, when submitting their NDCs. And the use of the verb forms aim to reach, should, will represent, are encouraged, may prepare, and other low density variants apparently undermine any attempt to pinpoint sufficiently characterized legal obligations. This I mentioned before, and it's not a coincidence that the request to the ICJ refers to the Paris Agreement, and I quote, as expression of the determination to address climate change. It never mentions as a source of a binding obligation. But end in end, the Paris Agreement refers to due diligence, procedural obligations, which are, as the name implies, legal obligations and goals-oriented legal obligations. So one can say that states' systemic lack of ambition or underperformance is ipso facto an infringement of the Paris Agreement, irrespective of any damage being produced. This argument is obvious, is a direct outcome of being a due diligence obligation, but strangely enough, it has not been highlighted in the written statements already disclosed to the public. Moreover, cross-regime interaction can be key. True that Article 192 of the UNCLOS is completely unhelpful, that's correct, but Article 194 and the following provisions, they do set out states' obligations to take all necessary measures to prevent, reduce, and control pollution of the marine environment, but does not prohibit. Once again, a goals-oriented due diligence obligation of means can be identified, and we can qualify it as a medium density obligation, since these provisions are so conditional that their obligational scope is highly mitigated by a prior understanding of what is necessary, possible, or available. So one way out is to qualify the standard of conduct under the UNCLOS according to a state's NDC under the Paris Agreement, which can fire back as some of these NDCs are clearly under-ambitious. Plus, the standard of conduct under the UNCLOS is objective and one size fits all, as should be with European Convention, but NDCs are country-driven and self-determined. So perhaps we can do the opposite and see if the UNCLOS can be the benchmark to assess the substance of a state's NDC. Honestly, I'm not sure if this would be helpful or if states would accept the substantive third-party validation of their NDCs. And would that imply, for instance, that an NDC could thus be brought before the ITLOS or the ICJ, alternatively to Article 24 of the Paris Agreement? But especially my concern here is that we just enter in a loop, in a never-ending cross-refer cycle, assessing standards of conduct among these treaties. So this explains why some authors refer and prefer referring to climate-related obligations directly under the UNCLOS or directly under the Paris Agreement. Because otherwise, if we put a flag in both treaties saying there's nothing to see here, or as one state said, there's a deficit of effectiveness here, strange, a developing state said that, then the question is, can the sum of all deficits provide a superavit? Or in other words, if we flag this way, will the ICJ and the ITLOS provide the answer we want? Probably not. Now, good news. Courts have already pinpointed specific states' obligations under Part 12 of the UNCLOS. All of them procedural and all of them stemming from environmental law. Surprise, surprise. So perhaps the way out is to look to environmental law and see if it can inform the interpretation of the Paris Agreement and the UNCLOS. And the answer is obviously yes, it can. Good news. But before rejoicing, can we see that we did not discover the elixir of life or the philosopher's stone, but just a Columbus egg? Because we are limited to the very same procedural due diligence obligations of means. Again, we are in a loop here. Another way out is to look to human rights law. That task is for my colleagues before and after me. But let me note one thing. I cannot understand why states have failed to bring an argument under the considerations of humanity before the ITLOS. This would be very far-fetched, and it was taught for the exercise of enforcement jurisdiction. But still, the ITLOS has said that when a state exercises any kind of jurisdiction, it must take into account what is the human impact of that exercise of power. So instead of looking to human rights and then raising problems, methodological problems, looking to a solid case law on considerations of humanity could have been a better way out in this regard. Then, and this is probably my fault, but also I cannot understand why compensation claims have been produced, thought of, conceived of, based on a liability matrix, which only raises problems to prove causation, to prove unlawfulness of the conduct, to prove who's the wrongdoer, who's the victim, so what will be the specific compensation afforded. So we just have red flags signaling to us that perhaps that's the wrong way. Not necessarily, of course, but perhaps there is a more nuanced and a more appropriate approach based on unjust enrichment. I hate this expression, I'm sorry. nothing against the doctrine, but the expression itself, unjust enrichment, which, if we think about the atmosphere as a global thing, we can actually say that there was a use of this thing by some states. Lawful or unlawful, it's completely irrelevant, but with detrimental effects that impairs the use of that thing by other states. Perhaps it can be a clearer, straightforward way out of this conundrum. This would circumvent the guilty-based arguments and the difficult search for an infringed obligation under international law. So to conclude, I think I just have 3 minutes. Okay, 1 minute. The main difficulty in international climate litigation is to find sufficiently characterized, legally binding obligations. But step by step, we can get there. And perhaps in that moment, we can address the elephant in the room, which is, okay, now this is, me as a court, I can say, states, what you're doing is unlawful, but what will be my exact ruling? What will I order you, state, to do very specifically? So we have lots of case law from the European Court and others that can help, but still in a very intangible and vague way. Thank you very much.
Okay, thank you very much. Impeccable time. And also everything you have said is music to my ears. So I won't comment any further. So we'll move on now to Talia, who I believe is online, if not very shortly. Talia, hello. So thank you very much, Talia, for being here with us. Well, virtually. Talia serves currently as a postdoctoral researcher with Translitigate at Tilburg University in Netherlands. Before going into academia, she accumulated years of experience working with international and local legislators, policymakers, and ombudspersons in Mexico, the US, and the UK. She's currently also affiliated with the Center on Law and Social Transformation at Bergen University in Norway. So Talia, thank you very much. And the floor is yours.
Thank you, Eloisa. Muito obrigada. It's really a true honor to share this platform with all of you today. And I extend my heartfelt gratitude to the University of Lisbon Law School for inviting me to this space. Of course, a special appreciation, if I may, to your work, but also to Carla Amado Gomez, to Margarita Vidal, and last but not least, to Paulo Nieto, who has relentlessly supported us throughout the technical issues. So today, in this roundtable on the legal rounds in international climate litigation, I am delighted to share with you during the next 7 to 10 minutes an overview of how the Inter-American Court of Human Rights has dealt with the issue of the climate emergency. And afterwards, of course, I'm happy to take your questions and delve a little bit deeper into a comparative lens with the work of the European Court. So particularly my presentation today will touch on 3 key points. First, I will briefly walk you through the normative trajectory that climate change as a human rights issue has taken in the Inter-American human rights system, but simultaneously gesturing towards the universal human rights system and the European Court as well. Then, as a second point, I will dive specifically into the contentious jurisdiction of the court, that is an overview of the milestone cases in environmental protection and also most recently in climate change. And then I'll finally address the value of the court's advisory jurisdiction, of course, primarily by going into the main aspects of the Advisory Opinion 23 on the environment and human rights and the ongoing works to potentially issue one on the climate emergency per se. So, how climate change has become an issue of human rights before the Inter-American Court of Human Rights. In legally grappling with climate change, the work of the Inter-American Court has made, I would say, an extraordinary leap from the first ever climate case before an international tribunal, which the Commission dismissed even before consideration of its admissibility in 2006, to the most recent jurisprudence acknowledging the right to a healthy environment as a standalone right under the American Convention on Human Rights, namely the Laca-Honat versus Argentina case in 2020, and the current processing of an upcoming advisory opinion linking the scope of human rights obligation relative to the climate emergency. So there's been, over these past 2 decades, a quantum leap between these developments. Throughout this trajectory, I must say, and what you are seeing here displayed is just a very, very abbreviated timeline. Of course, there are plenty of more case law developments and also reports from the Human Rights Commission, but this is very abbreviated, just to highlight and flag what the key advancements have been throughout this trajectory. And over these years, the Inter-American system has developed interpretations linking the environment, human rights, and more recently, climate change, which have informed, of course, and have flown to the work of the UN Human Rights Committee, and also has informed some reasonings at the European side. But before the right to a healthy environment was acknowledged as a standalone right, as I mentioned in the Laca-Honat case just 3 years ago in 2020, the case law evolution was enabled through the notions, and this is very crucial, of the right to life, which has been consistently used to protect individuals from environmental degradation. And for example, a significant milestone in this direction was provided in the Yaque Aya versus Paraguay case in 2005, but also earlier, environmental cases drew heavily on the rights to health and the rights to ancestral property of indigenous peoples. A key milestone here was the Aguas-Tini versus Nicaragua case in 2001, and more recently, the Saramaca people versus Suriname case in 2007. But when we zoom into this abbreviated timeline and take some steps back, what happened just a few decades ago in 2005? Well, as some of you may be aware, an Inuit woman representing a group of Inuit people, Sheila Watt-Cloutier, tried to hold the United States accountable for failing to reduce greenhouse gas emissions, thereby impacting and infringing upon these people's rights, especially to culture, to food, to health, due to, for instance, changing species distribution. This failure of the United States also jeopardized future generations, but unfortunately, the Commission rejected the case just 1 year after the petition was filed in 2006, prior to even assessing the case's admissibility. However, while the Commission did not agree to hear the Inuit case on its merits, the petition itself garnered attention and prompted the system, the Inter-American system, to move forward into incorporating the climate dimension into its work. For instance, just 3 years after the Inuit petition, the General Assembly of the Organization of American States adopted Resolution 2429, by which it called the Commission to incorporate climate change concerns into its work and work in a coordinated fashion with all member states to move along this direction. So even when success before international tribunal seems not to be success in the material sense, in the symbolic sense, it can prompt political momentum to advance forward. And also when we see this trajectory coupled with what has happened at the universal human rights protection system, then there are significant overlaps between what happened, the adoption of the OAS General Assembly resolution, and also the first ever resolution by the Human Rights Council back in 2008. And it's also noteworthy to recall that just a decade after, in 2016, if I'm not mistaken, the Republic of Colombia requested the court to clarify the scope of human rights obligations, particularly in relation with the environment. And in response, as we all know, in 2017, the court issued the advisory, the landmark advisory opinion 23, in which several commentators have highlighted how this constitutes mainly and crucially a milestone in the progressive rapprochement between climate change law and international human rights law along three different lines. And the first line, I will not delve into these lines, but in the following slides, I will do as I deep dive into the advisory function of the court. But important for now is to just flag the 2020 Laca-Honat case versus Argentina, in which the court acknowledged for the first time as the right to a healthy environment as a standalone right. And also just last but not least, Resolution 321 adopted by the Commission, which in which the Commission advanced several human rights standards, but particularly from a very intersectional perspective, which flagged what the particular burdens are faced by groups that have historically lived in marginalized conditions, such as indigenous groups, but also people in urban spaces as well. So in the next slides, I will dive a little bit deeper as promised and very, very shortly, just to honor the time, into such developments. So the Inter-American Court has played a very, I would say, in my reading, a very pivotal role in addressing environmental issues, particularly and centrally, it has intertwined those reasonings with indigenous rights and with the right to health, while also adhering to the American Convention on Human Rights. It has done so very briefly along the substantive and procedural rights we have discussed, or my previous co-panelists have discussed throughout this workshop. So initially, the court concentrated on enforcing Article 21 of the American Convention, which is the right to property, and indirectly reasoned and derived the right to access to ancestral property by indigenous communities, ensuring thereby the protection of indigenous communities and recognizing, of course, their intrinsic connection with these territories. As I mentioned earlier, a key milestone here was the Awastini community versus Nicaragua. And then gradually, the court expanded its scope to encompass the right to health, aligning with Article 5 of the American Convention and highlighting the direct impact of environmental degradation on physical well-being, as well as access to vital resources as flagged by the Yaqui-Axa indigenous community versus Paraguay. And more recently, the Laca-Honat Association versus Argentina is a super important case, not only because it recognized the right to health as a standalone right, but also because in so doing, the court acknowledged and reinforced the principle of indivisibility and progressive achievement to the maximum available resources of the fulfillment of such rights. So it's a cornerstone interpretation that, in my view, will allow to legally hold accountable not only in relation to mitigation, but also positive obligations in relation to adaptation. Moreover, in the procedural field of reasoning, and this is a key contrast with what has happened at the European Court of Human Rights, not only both courts have advanced criteria on procedural safeguards such as access to information, participation in decision-making, and access to justice. But crucially, the Inter-American Court has distinctively, in so doing, also and simultaneously advanced interpretation encompassing fundamental freedoms of thought, expression, and association just to protect environmental activists and human rights defenders simultaneously, which was a question that was asked during the previous panel as well. So the Inter-American Court has advanced in this particular direction. And finally, just in these 2 minutes that are left, I would say that the advisory opinion 23, even though it's environmental related and it overlooked some special and inherent aspects of how climate change has unfolded in the region, it holds and carries distinctive legal and social value because sometimes, and in the most of cases, take decades to advance through the court's contentious jurisdiction. Nonetheless, this advisory opinion was just issued a few months, if I'm not mistaken, just after the request by the Republic of Colombia, and it issued and it cast light on several interpretive spots that were halted at the moment, one of which is the extraterritoriality, of course, and the duty to protect even beyond the country's own borders. So it said the scope for extraterritorial obligations, but also it elaborates on the prevention of environmental harm, the precautionary principle, and procedural duties, and the duties to international cooperation based on the notion of and the principle of different and common responsibilities as well. And finally, as you all know, some workings are in the oven. Just in San Jose, just earlier this year, Colombia and Chile requested an advisory opinion on the climate emergency and human rights along 6 main issues. One is the duty to prevent further degradation and the duties inherent to the right to life. Importantly, the right to life in the Inter-American field is interpreted as the right to a decent level and standard of life, giving rise to positive obligations not only to develop a sound and effective regulatory framework, but also entitlements to provide basic public services. Also, the third issue that both countries require the court to clarify is the rights of children and new generations, consultation and judicial procedures, the protection of environmental defenders, and also common but differentiated responsibilities. This advisory opinion will have implications for normative tools, as it can be used by the increasing wave of domestic climate litigation that the region has undergone lately, but also because in the region distinctively the human rights framework hold not only legal but also social and political meaning. This advisory opinion can possibly catalyze modifications and integrated policy making, for instance, across various sectors, importantly health and also migration. In the face of increasing climate displacement. So just a kind of reminder, the deadline to submit observation has been recently extended till December 18. So you can submit your obligations, the findings of your research, if you consider them relevant for this important body to further develop the advisory opinion, to the email that appears on the slide. And I'll leave it there for now. Muito obrigada. And I'm very happy to take your questions and to delve a little bit deeper into the contrasts between the Inter-American field and the European Court. Thank you.
All right, Talia, thank you very much. And now we are going to move on to something completely different. So Joana Gama Gomes will be talking about the Court of Justice of the EU. She's a legal counsel at the Portuguese Central Bank. She's a researcher here at the Lisbon Public Law Research Center, and she's a guest lecturer and a PhD candidate here at the University of Lisbon. So the floor is yours, Joana. Thank you very much.
Well, good morning. On this panel, I was asked to give a brief presentation on legal grounds in climate litigation on the view of the Court of Justice of the European Union. Because this topic is very broad, I decided to bring you today a view on climate litigation related to a very kind, in particular, European institution, the European Central Bank. So climate litigation is also now the reality for central banks. But why are central banks relevant in reaching climate policies and climate goals? So within the European Union, central banks are independent public institutions responsible for the monetary policies of the euro area. Before the global financial crisis, the ECB mainly conducted monetary policy by setting interest rates. But now it has a very diverse set of policy instruments it can use to ensure financial stability. And they include, among others, purchasing private and public financial assets. And please focus on the CSPP purchase program, because we will come back to it later. So the ECB purchases billions and billions in financial assets from various companies. And these financial assets have been found to have a carbon bias, as a large part of them belong to particular high emitting industries, such as the fossil fuels industry, the chemicals and plastics. But the ECB is completely independent in its decisions. It enjoys a broad discretion in designing and implementing monetary policy and cannot take instructions from the Commission or from national governments. So is the ECB, is the European Central Bank, bound by the EU's environmental targets and by the EU's international obligations on climate? In recent years, many scholars have defended that taking climate change into consideration in monetary policy by the ECB is not just an option, but it is a legal obligation of the European Central Bank. In particular, it has been argued that through Article 11 of the TFEU, the ECB would have an obligation to take into account environmental protection when defining and implementing monetary policy. So when defining which assets to purchase in the financial markets. According to the case law of the Court of Justice of the European Union on Article 11 of the TFEU, the validity of an EU act, an active EU institution, would be compromised if the institution would fail to actively engage with relevant scientific data when designing legal rules and legal policies. So the ECB would also have this obligation to Article 7 of the TFEU, which says that the EU shall ensure consistency between the policies and activities of all institutions. However, on the other side, we have people arguing that the ECB, because it acts in open markets through the principle of market neutrality, cannot provide preferential treatment and credit to green activities or companies. So if the Euro system, which is the central banks of European states and the ECB, would take a more proactive approach to the promotion of environmental protection, others might seek to challenge the validity of ECB decisions and of these programs that I showed you before, on the grounds that by taking a too proactive approach on environmental protection, the ECB would be overstepping its mandate as defined in the treaties, because the treaties only give the ECB power to maintain price stability and not to promote environmental policies. And here, I say we could take some clues from well-known decisions, especially of the German Federal Constitutional Court in Goweiler and Weiss, which have challenged the scope of the mandate of the ECB. But as we reflect on climate change before the Court of Justice and climate change related to central banks, we have to recall the only case we have had in Europe. This is the recent case filed against the National Bank of Belgium, the NBB, by Client Earth, a very known environmental law charity. So in April 2021, Client Earth filed a case before the Belgian courts against the National Bank of Belgium, challenging the bank's implementation of the CSPP, which is one of the purchasing programs that I showed you before. In particular, Climate Earth noted that half of the bonds that had been purchased under this program had been purchased from high-emitting companies. As I said before, fossil fuels, chemicals, etc. What is relevant in terms of EU law is that Client Earth challenged the validity of the purchasing program on the grounds that the ECB, which is responsible for the design of the program, and the National Bank of Belgium, which is responsible for the implementation of the program, had failed to take into account environmental protection requirements when buying assets under the CSPP in breach of their legal obligations. So Client Earth, during the case, sought a preliminary ruling to the Court of Justice of the European Union, questioning the validity of the CSPP decision, which is a decision of the European Central Bank, a EU institution, on the grounds of violation of Articles 11 and 7 of the TFEU, and also on the very known Article 37 of the Charter of Fundamental Rights. The case was, however, dropped by Client Earth because the ECB has voluntarily accepted and adopted environmental guidelines into its monetary policy instruments. And so we never got a definitive answer from the Court of Justice of the European Union on whether the Euro system, the central banks of European countries, and the ECB are in fact in compliance with the provisions of the treaty, and if taking climate change into their monetary policies is not an option, but rather a legal obligation that derives from the EU treaties. Nonetheless, some have said that even if the Court of Justice were to side with Client Earth and say that this was a legal obligation, and it is a legal obligation under EU law, the court would not declare void purchasing programs like this, because this would have it could have a massive potential impact on financial markets, because they are already underway for several years. However, it is important to say that Client Earth, when it filed the case, it asked the court to order the Belgian central bank to stop purchasing bonds under the program. However, until a decision by the court, which we did not have in this case, however, this analysis remains speculative, but we look forward to more cases to see if they reach the court and we got a definitive answer on this problem. Thank you.
Okay, so thank you very much. Like I said, something completely different, but sometimes in environmental law, we are very much focused on environmental law and human rights, and this is a truly cross-cutting topic, so we need to consider all of this. So now I will give the floor back to Armando if you want to make comments, etc., since Vladislava is still not back. I'm not sure if she will be. So I'll give you the floor for a few comments, developments, etc.
Okay, so perhaps just a few ones. Want to say something that could be surprising for those who are unfamiliar with these topics. I'm sure no one in the audience fits in this category, but could you see that this conference was so well organized, but you had much more time for human rights than for international law or the law of this. In fact, the UN system was packed in one single intervention. And why? It's surprising, or perhaps no, that it's much easier to flesh out specific obligations under human rights law than under general environmental law, international law, or the Paris Agreement. It could be surprising, but for everyone in this classroom, it's not. But perhaps it can be a sad symptom. Even one thing that, and this actually surprises me a lot, is why we are still trying to talk about precaution under human rights law. Vladislava was made a wonderful speech about precaution under the European Court of, according to European Court of Human Rights. But this is a principle which is in crisis in environmental law, and with respect to climate change, it was specifically dropped. It was mentioned in 1992 in the UNFCCC, and then in the Paris Agreement, the drafters decided that it was completely useless and it made no sense in 2015 and much less in 2023. But still we have a human rights court which is able to unveil obligations from this principle, which was relatively zombie or almost dead, but suddenly there was a breath of life provided to the principle under human rights law. There might be a very good explanation for this, which is sometimes when we work in a specific field, we tend to see it as a theory of everything under the world and under the sun. It's normal. It just means that we spend too much time reading those treaties and those particular scholarship. And when we deal with climate change law, as I do, my first answer to you would be that all answers are provided in the Paris Agreement. At least I'm wise enough to know it's not that correct. But in fact, something that passes unnoticed very often is the fact that this is just, the Paris Agreement is just a framework convention. Although it tries to implement a framework convention, because climate change affects every single aspect of our lives, it basically defines the tenets of what needs to be then implemented domestically by states. And because this is very cross-sectorial, if we win or lose this battle to have a healthy atmosphere and life on our planet, at least as we know, the fighting field will not be the Paris Agreement. It will be on a daily basis, national, domestic, sectorial policies that are adopted with respect to transport, housing, energy. We need to look to the UNFCCC and the Paris Agreement just as framework instruments that then need to be implemented. In any case, there are still some problems that I can see. There is a long way lying ahead of us. For instance, we had a wonderful speech by Vladislav again, and then we had Talia mentioning the resolution from the 2022 of the American Commission on Human Rights, if I'm not wrong. I think it's Resolution 3/2022, where it is a very long and detailed list of climate-related obligations, which mean that, after all, it's possible to have a full list or a very complete list of specific state obligations related to climate change. Unless you actually read the judgments of the European Court of Human Rights and that specific resolution, and do realize that although documents are much longer, they are still very intangible and vague in the way they address states' obligations. So there is still a long way ahead of us to try to be more specific in the way we implement and where we specify these states' obligations, which explains why, again, we have this elephant in the room. So a couple of months ago, I had everyone in a conference I was attending at PowerPoint slides. And as you can see, I'm awfully PowerPoint slides. But because I was embarrassed for being the only one not to use them, I decided to Google Edward Munch, the Scream, and to put it behind me and to pretend it was like a PowerPoint slide. Why? Because first, that's how I think I would react if I was a judge receiving one of these applications or submissions and having to say something meaningful to the state. I would probably not like being in their shoes, especially because judges, they are lawyers and very good lawyers, but the problem with climate change is very sectorial. In states, they have the best persons, the wisest persons with scientific knowledge to know what to do with respect to climate change. If those persons cannot provide a solution, can we imagine judges who can be the most brilliant in the world, but lawyers providing these answers? Which then fires back, because what happens is that we may have rulings being not very specific, putting this pressure over states, and then states themselves are in the position of the character in Edward Munch's Scream. They know that they have a binding judgment that they need to implement, but they have not very specific idea on how to do it. Of course, in the European case, then they can be assisted by the committee of ministers, but still we are just passing the hot potato to different bodies, and still no one is being able to explain what specifically needs to be done. A very good example on the precaution is, and these due diligence obligations is, think about a nuclear plant. It's very easy to single out what obligations stem for a state in terms of monetarization, for instance. But if we think about greenhouse gas reductions, the task seems very simple. We need to reduce greenhouse gas emissions. But since emissions are connected with every single aspect of our life, including this Zoom session and the fact that we are breathing, it's not easy at all to define one single clear obligation under the precaution principle. And that's all.
Okay, Armando, thank you very much. Actually, yesterday we had a pre-workshop with Maria Antonia Tigre. And one of the things that we talked about is the fact that because legal standing rules for international courts are so strict, when we talk about international courts and climate change, we tend to focus on human rights courts because you have more cases, because people can actually file a lawsuit before those cases, make a request, etc. And that is not the case for the ICJ, for example, etc. So we tend to, in international law, to focus a lot more on human rights than, for example, at a national level, to focus on constitutional rights, which would be the parallel. And the difference is that we can access national courts, but we as individuals or NGOs can very difficultly access international courts. So we tend to focus. But I would add environmental principles, I think, are the way to go, but that's just my thing. Talia, what would you like to comment on all of this?
Thank you, Eloisa, and thank you, Armando, Joanna, and Vladislava. It was very, very insightful to learn about these contrasting, I wouldn't say contrasting, but converging fields in banking, central banking, but also along interpretive lines at the European Court. I would just flag, and this intervention will go and touch on 2 points, because I was left with Armando's saying about passing the hot potato to different bodies, and it seems like it's been the case. So my intervention will focus on 2 aspects. First, drawing on the evolution and the trajectory of reasoning that we've seen at the Inter-American system. I would like to flag how and the new horizons these could potentially take, and what this means for passing on the hot potato, to other fields of international law, if I may. And the second aspect I will try to touch on is to move a little bit beyond the legal boundaries and touch on the social movements literature and the distinctive meaning it carries in some other jurisdictions that also reverberates on how domestic judges, which are on the first line of reasoning, grasp with this issue. So regarding the trajectory and the evolution at the Inter-American Court, it's really distinctive to see how this has taken off from a very restricted, I would say, standpoint on causation, but also restricted to indigenous groups, until now to see how potentially the court could set a huge precedent, not only encompassing indigenous concerns, but also crucially to the broader population in the Americas, right? Also urban people and campesinos, for instance, who haven't historically been addressed by international law. As we all know, indigenous concerns have been taken up by the Indigenous Declaration, the ILO Convention, and so on and so forth. But as Armando also mentioned, climate change touches different aspects of human life. And now, this is something I didn't mention in my presentation, but now it's in the hands of the Inter-American Court to decide and potentially issue the first ruling on non-indigenous related environmental case, which is La Oroya case versus Peru. It's a mining case that concerns a campesino community in Peru. And this takes me to my second point. How, even though human rights gives a social language to vernacularize movements and concerns very particularly to each region of the world, it nonetheless becomes another bucket of the legal discipline, because it really it has a huge tension with international economic law. What will happen after a domestic constitutional court rules in favor of a vulnerable population, and then the foreign investor afterwards comes before the arbitration tribunal, right? We have seen all around Latin America cases that stand at this tension. And one of the potential aspects that the new advisory opinion on the climate emergency and human rights can flag is precisely where the hot potato stands when it stands at the crossroads between international human rights law and its mergence with international environmental law versus the architecture, the legal architecture and the underpinnings of international economic law. So I'll leave it there, and I believe that the next horizon in this regard is to aid interpretation doctrinally, but also from the social movement part, to kind of reach and overcome how to navigate and go about these hurdles, these tensions between fields of law, but between also jurisdictions.
Yeah, sure. Go ahead.
So if I might jump in and make one question to you, Tali, because, well, it's something that I'm not sure if there is an answer for this, but I like very much that you pointed this idea that perhaps an arbitration tribunal can say something in conflict with the ruling from a constitutional court. And your hope is that an advisory opinion can be used to uniformize views, the understanding on these climate-related ideas. Now, what if the Inter-American Court of Human Rights, the ICLOS and the ICJ render conflicting opinions? Which one will you use?
Well, that would be a very interesting scenario. I mean, even though we are not unaware of the fragmentation that international law has come to, I would render that scenario as least likely, but nonetheless, I believe that the conflict will arise not in an explicit way, but will leave like interpretation, this nebulous and gray area that's always left by international law to domestic interpretation. But to the point I was referring to, international environmental law and human rights versus international economic law, let me put like a very illustrative example in this regard, if I may. In Guatemala, for example, Guatemala holds one of the most important nickel reservoirs in the world, which is one critical mineral essential for the energy transition. And among the Americas, it's the country with the most indigenous population. And there, the conflicts between foreign investors and indigenous populations have skyrocketed during the previous decades. So for instance, Guatemalan's constitutional court has ruled in favor of recognizing the right to free, prior, and informed consent. Nonetheless, some mining corporations with US investors, for example, have gone to the World Bank panel and to arbitration tribunals, which have ongoing, the proceedings are ongoing, but claiming that their economic interests have been harmed because of these rulings of the domestic constitutional court, right? So we see that a very overt and very pressing tension. What the advisory opinion will say, I think it will not kind of balance those interests, but it will provide some grounds for the constitutional court to uphold in the principle of sovereignty, maybe to uphold their domestic rulings. I don't know. But in Ecuador, we had a ruling, if I'm not mistaken, just a few years ago, the Constitutional Court upholding the legality of a domestic court rolling over an arbitration award, right? So for courts, domestic courts, to innovate and to know what the pathway is when there are two conflicting fields of law and economic interests underpinning those conflicting areas of law, I think it's very unlikely unless they have a precedent, right? And we see now in the face of the energy transition that more than ever, we need such precedents, right? That's the point, not that I'm arguing that a balancing explicitly will come up out of this advisory opinion, but that eventually we'll recognize that those tensions are out there, that they are emerging out of new challenges, such as the energy transition, what that entails for the scope of obligations in human rights terms, and how the domestic operators legally can do to balance out which are the parameters they need to consider in order to advance new reasonings in that direction.
All right, thank you very much. Great discussion. So, Joanna, would you like to add anything on anything? I know your topic is quite different, but still.
Yeah, just to piggyback on something you said about legal standing. You have brought the topic of legal standing related to climate litigation in international courts, but this is also a major problem in EU law. And in the afternoon, Mario Pagano will speak about this very well, I believe. But even reaching the Court of Justice of the European Union is not easy for private individuals. We all know the difficulties of Article 263(4) of the TFEU, but this has been improved in the EU legal order by the ARAS regulation and all the procedural rights introduced by the ARAS Convention. And recently, there have also been some cases against another particular EU institution, not institution but body, the European Investment Bank. And client Earth. especially, has brought a case and won a case in the Court of Justice against the European Investment Bank. And now, and the court said that the European Investment Bank is also bound by the IRA's regulation and should disclosure environmental related decisions and all in its investments and to private individuals and NGOs which seek them directly. So this will be a very good topic for the afternoon that I'm sure you will like to.
Okay, thank you very much. So now I open the floor for anyone who wants to ask a question. There are no questions on the Q&A, at least not yet. Anyone at home or the office that want to ask a question, please do. But now we already have a question here.
Yes, thank you very much again to all the panels. This was really interesting. My name is Teresa Jürgensen, and I have a question regarding specifically the precaution obligation that has been talked about. And that is in relation to several, both the European Court and the Inter-American Court. Now, we were only talking about the knowledge requirement in terms of that there has to be knowledge, the state either had knowledge or ought to have no knowledge. However, what I want to ask about is the second part of this test, which is that there need to be knowledge of the real and immediate risk, according to the European Court and the Osman requirement, and the Inter-American Court has adopted this and also used the same requirement in its advisory opinion on the environment, same standard, I mean. So my question is specifically the immediacy element of it. Could that pose a problem specifically for climate change, considering that climate change is something that doesn't occur overnight? It has a temporal delay in a sense. Actions that we're doing today might take years or a long time to take effect. So there's a question about, is the risk immediate, and should this be interpreted in this way, or can it be interpreted in another way? And to that end, should we adopt that what the Uganda or the court said in the Uganda judgment, which is that this immediacy requirement should not be interpreted in a temporal sense, but instead simply that it needs like a direct link to the victims, I think. So specifically in regard to European Court and the Inter-American Court, yes, thank you.
Okay, thank you very much. Vladislav is not here, so I will ask, well, Talia and Armando, if you want to say anything on this, I can also, but who would like to go first? Maybe Talia, she was nodding very much. So Talia, possibly, could you go first?
Yes, of course. Thank you. Thank you, Teresa, for bringing up this question. At least my reading of the cases of the case law at the Inter-American Court and also the advisory opinion, this immediacy requirement has ontologically this very essential purpose, not to be in the absence, of course, in the absence of scientific certainty, the court easily has jumped to the precautionary principle through the right to life, interpreting the right to the right to a healthy environment as integral part of the right to life, and then to kind of navigate and bypass this strict requirement of having a causal nexus requiring scientific certainty to jump to the precautionary principle. Now, that immediacy requirement is done in a way, at least that is my reading of it, not to overstep and infringe on other human rights. That comes to our minds quite easily when we think about, for instance, like not granting new permits for highly intensive industries, right? But when we think about industries that are currently operating, if one argues on the immediacy requirement, just to close everything immediately due to the urgency of climate change, then that could potentially infringe upon workers' rights, right? So in the absence of scientific certainty, which has been, like I would say, seamlessly navigated as of now by the Inter-American Court, then it is confronted with other social rights and the immediacy of other obligations, the fulfillment of other equally important obligations. And that, as I was contending during my previous intervention, has to be weighed in by the specific circumstances of the case, of each individual case. So that is left to be seen. There are some cases in Chile, if I'm not mistaken, for instance, that involve this transition in terms of workers' rights, but that has to be seen and pondered in an individual basis. So I don't know if I'm answering your question, but just to answer your question in a summary, in a nutshell, the Inter-American Court, that's my reading, has jumped quite easily from the absence of a scientific and precisely knowledge to establish the causal connection to the precautionary principle. But when it comes to the immediate requirement, it has taken a cautionary approach when pondering the obligation vis-a-vis other substantive requirements for the fulfillment of other equally important rights.
All right, thank you very much.
So in my case, well, I can step in instead of Vladislav if she's not online. Well, if you talk about immediacy and how imminent is a risk and knowledge of that risk, then you're just rejecting precaution. There's nothing to do with precaution, but rather prevention. Perhaps that was the strategy of the European courts to be able to flesh out some obligations. And to know how imminent is a risk was very strategical for the European Court of Human Rights to allow environmental claims to be brought in, but to avoid being hijacked by any kind of environmental related claim. So that's why it also looks to Article 8 instead of Article 2 or 3, which would be much more evident, because they provide these spatial lenses to assess imminence of a risk. But especially what this shows, basically the problem is the chain of events. That's the question here, because climate change is really the Goliath of legal problems, in the sense that every single aspect that you want to assess can be easily solved if you talk about a nuclear plant or anything else. But when you apply it to climate change, then things mismatch. And in this case, the problem with imminency is that if you ask if someone is victim of climate change, now don't get me wrong, don't misinterpret what I'm going to say, but from a formalistic, positivistic angle, no one is victim of climate change. There is no human rights infringement from climate change. At most, you can say that states emit greenhouse gases, which concentrate in the atmosphere, whose concentration is very high, which then lead to global warming, which then leads to climate disruption, which then leads to extreme weather events, which then create hazards, which then eventually cause an infringement to your human right. And this chain of events is very clear, very undisputed, but very difficult to establish in single cases. That's the problem with climate science. It's not if overall we have climate change, but how to prove it specifically, but also very distant. Nowadays, we are feeling the effects of emissions 100 years ago. So the imminence of risk means that the tools that were devised by the European Court of Human Rights for avoid being hijacked, they do not work with climate change. So you have two options. They're not natural facts. So you can just change them and say, I don't care any longer about imminence of risk, and therefore I will take this case on climate change and any single environmental related case. Or you just say, I will stick to my prior case law because I'm afraid of enlarging the pool of potential applicants. This at some point will be, I think, a political decision, in the sense that unless the European Court is able to express very clear and objective criteria for allowing in climate change and not anything else, unless it is able to do so, what it is basically deciding is how many applications it is willing to accept in the future related to climate change, to environmental law, not only climate change.
Talia, you can make your comment, Flo, if you want to.
Yes, thank you. I was just I wanted just to jump in to bring on to the fore and to the table the advancements and the steps that attribution science has made in that regard. But again, like in pondering against the collision of rights, it has been suggested that it should be taken in a very cautious way in establishing the responsibility, but also in learning how policy should be done in a way that compensates the least privileged populations with the way the transition is to be carried out.
All right. Any more questions from anyone? I know we all want to go out to lunch, but still. I argue with this topic of causality a lot. Well, all of us, obviously, but I have studied environmental liability a lot, and it always was quite evident for me that liability was completely inadequate to deal with climate change, specifically because of the sources that are completely, well, not only transboundary, the effects not only long distance, but also deferred in time. So it's impossible to deal with climate change with focus on, I thought, then I'll add something new, I hope. It's very difficult to deal with climate change in any type of legal instrument that requires causality demonstration. But last year, I had a student here who is a public prosecutor in Brazil, and he was making the case for, well, the lawsuits that he files in Brazil that are liability cases, and how did they overcome this problem of causality? Well, instead of demonstrating causality between climate change damage and climate change and climate change damage in a specific case, they have been not going to the end of the chain, but to the middle. So instead of demanding liability because of climate change damage, they will require liability for the act at the origin of the damage itself, specifically deforestation. So instead of trying to say that there is a damage like flood destroyed my house or whatever, and the source of emissions, you would just go directly to the source of not reducing or increasing greenhouse gas emissions, so deforestation specifically, and say this is a damage in itself. I don't have to go to the end of the chain. We are very much focused on human rights again, so we always think at the last consequence, not only for human rights, but also environmentally, but you can go directly to the source and say this is a damage in itself, not only because of itself, so trees themselves as the object of legal protection and forests, but also because we know that this will lead to an increase in greenhouse gas emissions, etc. And this is a problem in itself. This is a damage in itself. So not going to the end of the chain. I think that is a very clever try to overcome it. They use essentially, just to wrap it up, they use essentially the carbon cost. It's a very anthropocentric notion, so it's carbon social cost. But if we can move forward, not in law, but in other areas of science, if we can move forward to calculating what is the carbon cost, not just for human interests and rights, but also for the environment, then maybe we can use liability more effectively.
Which means that, if I may, that's what you're saying, that it's much easier to have a successful case if it's duty-based than rights-based.
Yes.
And probably the ultimate evidence of that is that if you look to the one problem with the standing requirements in the case before the European Court of Human Rights is that I assume that most of you have read or are familiar with the cases, but have you realized that no one could prove that were victims of lack of mitigation? In fact, what they said was that they were being victims of lack of adaptation.
Exactly.
So the only rights-based approach probably is to highlight adaptation, but not mitigation, which is a problem because there is a limit to how much you can adapt to climate change. So probably duty-based approaches can be more successful.
Well, yeah, maybe we can build on duties to prevent the need for adaptation measures.
Yes.
You want to follow up on that? Go ahead. Yeah.
So that was very interesting idea that you presented, and I was just wondering how this can be integrated, however, in what rights-based litigation, just because it is the most litigatable matter that we have as of now. And what you were saying reminded me a little bit of the approach that the Inter-American Court adopted in regards to extraterritorial jurisdiction in environmental matters, because in reality, I was rereading what it said exactly the other day, and they created this idea that basically it makes sense, basically because the states have jurisdiction over the source of the origin, they have jurisdiction over the people that suffer the harm from it, which it's questionable whether that really can be interpreted into, if you just read through the text of territorial jurisdiction really in the convention, but it seems to apply a very similar idea of what you were saying, because you control the source, because of that you then also control the harm. So I was wondering if this can be applied to extraterritorial jurisdiction, if we could also apply it to, well, causation and the knowledge requirement, as we talked about earlier, in terms of the intertemporal dimension to climate change.
Well, the thing is, I think that this solution actually allows you to say there's no extraterritorial problem here, because what you are discussing is only the deforestation, so you can actually avoid that problem. It's true that not completely, in the sense that, of course, we know that the damage that is being caused is not just locally, so it's not just a problem of deforestation, but it becomes very clear that you have only the control of that action happened in your territory. So it's more focused on the territory under jurisdiction of the state than extraterritorial. But there is, of course, always an extraterritorial dimension to it, because we are not only considering the fact that we are damaging that forest. We are also considering extraterritorial effects, but not quite as centrally as in if you're considering human rights, for example. And I also have a very favorable approach to duties based, although this goes into legal theory and duties correspond to rights and rights correspond to duties, etc. So, but we, it's almost lunchtime, so I'm not gonna go into that. Yes, microphone.
Because I have high tone, but
it's just so people can hear.
It's so curious that you're bringing that, Eloisa, because about your thesis, my approach was completely different. As you know, you went to human rights approach, and I always said we have to follow the ecological trend. We have to aim for the ecological damage. And that's what it's at stake here. We are aiming the damage, the direct damage to forest, and the indirect damage to people. And doesn't it contend with the low legal standing? How do you go to court to defend a meta individual good if you don't have actio popularis? You know, we can do this very easily in Portugal, but not in an international court. Of course, you are saying that they use this in Brazil in internal courts. Great.
Exactly.
We can do this here. But aren't we? It looks like we're stepping backwards. I always defended that, but it looks like we're stepping backwards, that human rights are not good enough. So we're going to change the perspective towards the environment. I think it's the right side, but it's interesting that you bring this.
Well, I'm not going to argue my thesis now, but my point when I went into human rights, because I'm much more focused always on duties than specifically on rights, which is why I very much like to study environmental legal principles. The truth is, we do not have generic norms concerning environmental protection like we have on human rights. A human right to life is a legal principle in structure. It's not a legal rule. So you can use it to extract generic principles, like the principle of reparation, which is what I was trying to get to. But my point here is you can use both instruments. So there's not like a fight here. Who are we going to go to, duties or to rights? We will go to whatever is adequate to try to address this from a legal perspective. But of course, international courts have a very limited role here because, exactly like we talked earlier, human rights courts have access, people have access to human rights, even though it's strict and you have to prove a direct effect, direct damage, direct interest, etc. But still, it's a lot broader than access to other international courts, which is why I believe we are witnessing something that is very interesting and that legal scholars from international law have been arguing for years, which is it's not true that international law does not have courts. with mandatory jurisdiction. It's national courts. National courts are the mandatory jurisdiction courts for arguing in most states, to argue international law and to enforce international law. So I think that's what is happening in climate litigation. Climate litigation is very clearly going to national courts because, well, individuals, NGOs can't get to international courts. So, and they can use both environmental legal principles, constitutions to try to enforce duties, or they can use human rights to go to a rights approach. Human rights culturally have a lot of weight, which is why judges feel more comfortable using human right to life than going with legal principles, environmental legal principles, most of which are procedural and not substantive. So I think this gives us the notion that we have a lot of different instruments and different ways to go. And my point was, liability is usually a strong legal instrument, but for climate change, it is very difficult. And I think that's an interesting path to use this legal instrument that courts are used to. I mean, we have to understand that judges are conservative. They don't like to go into very disruptive political issues, especially in Europe. So if that is completely true in Europe, so if we want to have judges decide substantially cases in environmental law and in climate change, we need to use legal instruments that are consensual, that have been used, that you have a lot of case law, like human rights and liability. Liability is nice if we can overcome the problem of causality. So that would be my conclusion on that. Okay, we are absolutely out of time. I'm sorry, I ended up talking a lot. Go ahead.
I'm sorry, I can't resist. Just one more thing. Isn't that the trend that Neubauer followed? Didn't the Constitutional Court said state has the duty to protect environment and the climate because it's the framework to the exercise of several human rights.
The thing is that the German constitution, in my opinion, has the best constitutional framework for environmental protection because it very clearly determines that it's a state duty concerning the foundations of life, which is the object of legal protection in environmental law. So everything else is useful, but not really the specific object of environmental law. But I think we cannot ignore that legal norms apply to environmental problems, even when they're not environmental law, like human rights law. And we cannot, and we should not. So we cannot legally, and we should not if we're, activists. Okay, so I think we can wrap this session up. No questions online. So now we'll go for a lunch break, and we'll get back at 2:30, so an hour and a half from now. Thank you very much.
Thank you.